All right, good morning, everyone. I'm Judge Corey Amanda Cawthon. This is First Appearance Court. I apologize to everyone for the delay today. We did have some issues getting our paperwork, and we have a very large docket. Today, I will let everyone know if I have determined probable cause, and we will talk about release conditions. A reminder to everyone that today is not your trial date, and so I do encourage you to speak with your attorneys before speaking on the record today, as everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom with me and are able to address your cases from here. When I call your name, if your attorney is not in the courtroom, then you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that this morning I have in the courtroom with me attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here with us this morning to help facilitate the session and to provide any additional information that may be needed. Some of you may be able to resolve your cases this morning if you are here on misdemeanors or municipal ordinance matters, but understand that that is dependent on what is going on with you personally and your case. For those of you present on felony matters or violations of probation where the judge has already set a no bond hold, know that that cannot be changed or resolved here at First Appearances. Following today's hearing, your case will be assigned to a division judge, and going forward, all pretrial motions and any subsequent trial will be heard by your division judge. Now, before I get started, we do have a number of people signed in, but let me just first ask Mr. Romero, is there anyone that may needs to be taken out of turn?
Judge, there was initially 3, but one of them, unfortunately, is going to be a medical reset now, so there's 2.
Okay.
First person would be on page 11 of the court's docket, and his name is, he's in the restroom?
Yeah, in the restroom.
Is Mr. Payu, and he's in the restroom right now, Judge.
Okay, how do you spell his last name?
P-U-Y-A, Puya,
Okay, and who's the other one?
and Mr. Sermons on page 32 of the docket.
All right, I'm gonna pull those out. Whoever is present will do theirs, and then I'll go to the sign-ins. It's on page 32 first. I just need to get his paperwork. Oh, yeah. I know. All right, good morning, Mr. Sermons.
Good morning, Judge.
Mr. Sermons, you're before the court this morning on 4 charges. Count 1 is for possession or use of drug paraphernalia. Counts 2, 3, and 4 are each a separate count for a felony probation violation. Those have no bond holds. I find probable cause. I do see, Mr. Sermons, you have a hearing before your division judge tomorrow morning on the VOPs. In light of that, do the parties wish to be heard on count 1?
Judge, not as to count 1, but as to count 2, I was speaking with Mr. Sermons. My understanding is he was taken into custody last year on that violation of probation in front of Judge Uson. My understanding, the violation of probation was addressed. He was basically sentenced to 8 months in county jail.
Yes.
And upon successful completion of the SAP program, his probation was supposed to automatically terminate. For what he advised me, he was released January 1st of this year. So from his understanding, that probation case should have been terminated. So I wanted to see if Mr. Lunder could look in Odyssey to see if that is what is reflected.
Okay.
And Judge, also one other thing, the mic is really low today. For some reason, I'm having a hard time hearing.
Well, it's Thursday, so I'm not surprised.
Mr. Sermons can be ROR'd on count 2.
All right, Mr. Linders confirmed count 2 will be an ROR. And as to the other counts, count 1, I'll leave the standard bond in place, and he'll see his division judge on the other 2 VOPs tomorrow morning.
No, Judge, actually, the other two VOPs, I believe they're out of state.
Are they? Let me see. Are they?
Yes.
They're out of state? Okay. All right, well then I guess he won't be seeing the division judge tomorrow morning. Okay,
No, what I told him is he would be going to extradition court, and there he can clear up some of the issues also he has with that.
okay, all right, thank you very much. Good luck, Mr. Shermans. Okay.
I'm not finding paperwork on that. P-U-I-A.
Booyah?
Yeah, page 11.
Is
Yeah.
that his last name?
Yeah, and I checked the docket to be sure that it's spelled right. Let me go through, maybe it's just me.
All right, well, we're looking for the paperwork on Mr. Puya, and I don't know if he's in the restroom or not. I'm gonna go ahead and, okay, I'll go ahead and go to our sign-ins, and then when he's back and we have the paperwork, we'll go. So next up is going to be on page 6, Kelly Dixon. Her private counsel is present in the courtroom.
Your private attorney.
Good morning, Your Honor. Frank Maester on behalf of Kelly
Good
Dixon.
morning. Good morning, Ms. Dixon. Ms. Dixon, you are before the court this morning on a charge for aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I will hear from the parties.
Your Honor, we've reached an agreement if it's acceptable to the court.
Okay.
Bond would be set at $10,000. No victim contact, no possession of any firearms, weapons, or ammunition.
That's correct.
All
As
right.
much as I enjoy sparring with Mr. Linda.
We have a large docket today. There's no time
Exactly
for that.
that. Thank you.
All right, I will adopt the agreement of the parties. The bond will be set at $10,000. There will be an order of no victim contact and no weapons, firearms, or ammunition. Ms. Dixon, so that you understand those orders, no victim contact means you're not to be in the same place at the same time as the alleged victim. It also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, ma'am? Here, will you turn the mic on, ma'am?
Judge, at this time, I'm going to invoke on her behalf her right to remain silent.
Okay.
I will discuss with her what specifically that means. Her family are in the process of posting bonds, and I'm going to ask that she not say anything other than to say yes, she understands the court's instructions.
All right, Ms. Dixon?
Yes.
Okay. And there's also going to be an order that you possess no weapons, firearms, or ammunition. That means that if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, ma'am.
All right, thank you very much. Good luck.
Thank you, Your Honor.
All right. Oh,
Judge, and Mr. Puyol
has-
is ready, whenever the court's ready.
it's right here. It's right here. He has family signed it. All right. Okay, we have Mr. Ernest Puya. He has family present in the courtroom as well.
Yes, he's coming up, Judge.
All right. We'll get there.
He's approaching, Judge.
Thank you. All right. Good morning, Mr. Puya.
Yes.
Mr. Puya, you're before the court this morning on one charge of domestic battery by strangulation. I find probable cause. Let me just see first. Ma'am, are you here on Mr. Puya's case? Are you here just to observe or to speak? Okay, are you here to observe or to speak? Okay, so I'm just gonna say a couple.
Can't hear her, Judge.
I know, she's very softly spoken. She's telling me she's the alleged victim and that she is here to speak. Ma'am, there's a couple things I'm gonna say to you, okay? First of all, if you don't wanna speak, you don't have to, all right? If you're just here to observe, that's fine. If you do wanna speak, I remind everyone who wants to speak that everything we say is being recorded and can be used against you and potentially him at a later date. Do you understand that?
Yes, ma'am.
All right, if you do wanna speak, I'll place you under oath. I'm going to ask you to speak into the microphone that's there in front of you so that they can hear you at the main jail. It's very hard for them to hear, okay? All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, thank you. And please state your name and spell your last name.
Kimberly Russo Puya, RUSSO-PUYA.
All right. And Ms. Russo Puya, what is it that you would like to tell us today?
I'm afraid for me and my children, and I just want to be able to give him the opportunity to get out of our home that we mutually have shared for 18 years. Just let me leave and let me be with my children. I'm afraid that he said when he was hurting me that he would have me killed.
All right. Yes, was there something else? Okay. All right. At this time, I will hear from the parties as to bond and release conditions.
Your Honor, excuse me. Mr. Puya has no criminal history. I am going to be requesting a $15,000 bond, pretrial release of the GPS monitor, no victim contact, no contact with either of the children that are mentioned in the case. It appears they are witnesses, and this incident occurred in front of both of them. Your Honor, our office had contact, obviously, with Ms. Puya. She has already voiced her concerns. She's advised my office she's in great concern. I've also been advised that the 14-year-old juvenile that's referenced in the report became involved in this situation and suffered a fractured hand. I've been advised there's been prior violence in the relationship. She does have concerns that he will not follow a no victim contact order.
Thank you. Mr. Romero?
Judge, I was explaining to Mr. Puya the purposes of today's hearing is limited only to establish probable cause and reasonable release conditions. I did advise him he'll have his day in court to present his side of what happened. Having said that, as you heard, he has a clean record. He's been residing in our community for almost half a century now. He's 59 years old. He's self-employed. He's a business owner. He has his own automotive repair shop where he employs 3 individuals, Judge. He's also been living in our community quite a long time. He has his family here. He's a registered voter. My point on all this, Judge, is he has very strong ties to the community. He's not a flight risk, and he will be coming back to court. Now, I did advise him because of the domestic situation, the court's going to order no contact. He advised me he will abide and respect that court order, and he'll have no contact whatsoever. He's actually going to be probably residing at his place of business. I believe there's like a little RV, and that's where he's going to be staying. And rest assured, he's not going to have any sort of contact with the victim. But Judge, from what he advised me, he's not going to be able to afford to post a monetary bond, which the state has requested of $15,000. I'm going to be asking for a $5,000 bond on his behalf. Judge, considering he has no prior record, his very strong ties to the community, I believe that's a reasonable request, and that's what we're asking for at this time, Judge.
Mr. Linder, do you have the initials of the 2 children witnesses that were referenced? I don't see them in the
No,
report.
but we can get that, Your Honor.
All right. Bond in this case will be set at $10,000. If Mr. Puya does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact. There will also be an order that he not have contact with the 2 witnesses as alleged in the probable cause affidavit. I will get their initials so I can include them in the order. Mr. Puya, so that you understand, since you will be placed on a level 2 GPS monitor, that will include a 500-foot stay-away order from these individuals. That means that you are not to be within 500 feet of them. Do you understand that?
Yes.
Okay, thank you. Additionally, I just want to advise you that in addition to not being in the same place at the same time, the no contact orders also mean no phone calls, no text messages, no third-party contact, no social media until further order of the court. Do you understand that?
Yes.
Judge, my only request at this time is, and Mr. Puya just advised me of this, he does have certain belongings there that are pretty important for him.
My medication?
Judge, what we're asking is if the court would be inclined to allow Mr. Puya one time accompanied with law enforcement to retrieve that property. If not, can he get a third person to go ahead and basically pick up his belongings that are important to him?
Your Honor, can I just give everything to his, our mutual friend?
What I'm, at this time, Mr. Mayor, I will approve of a third party going, based on the information that I'm being given. I'm not going to approve Mr. Puya to go, but if he has somebody else that can go.
And I'll
then
have his
that would be
vehicle
fine.
delivered to his business as well with his medication and his clothes.
All right, it'll go through a third party.
Okay,
Your Honor,
Yes.
the initials are JMP
and I'll be out.
Ma'am, just ma'am, and ARR.
Okay. All right. I'll include their initials in the findings. All right, thank you.
Oh, I'm sorry, I
Yes.
forgot to request a photo order.
Yes, I'll sign a photo order. All right, thank you. Thank you, everyone. Okay, next I have, oh, there's James. Okay, I have a bondsman signed in on Thomas Nicholson. He's on page 11.
North Broward.
Thank you.
North Broward, Your Honor.
Thank you very much. Good morning, Mr. Nicholson.
Good morning, how you doing?
I'm well. Mr. Nicholson, you're before the court this morning on one charge of aggravated battery with a deadly weapon, domestic violence. I find probable cause. I do note that your bondsman is present in the courtroom, but first I will hear from the parties as to their recommendations.
Okay, Your Honor, I'm showing at a Dade County in 2010. Arrest for assaulting a law enforcement officer resisting without violence. Charge was dropped. 2010, he was arrested for 2 counts of domestic violence battery. Charges were dropped. Based on the level of violence, noting there was an independent witness, I'd be requesting a $7,500 bond and no victim contact.
Yes, ma'am. Your Honor, Mr. Nicholson is a lifetime resident of South Florida. He's been living here in the same address for the past 12 years. He's currently unemployed and receiving disability. He does have family in South Florida. He advises that he is a registered voter, and he further advises that he will have a place to live, separate and apart from the alleged victim, once this case is resolved. I'm sorry, once he is released.
Okay. Do you have any recommendation as to monetary amount?
Judge, he doesn't seem to have much of a criminal history. He is a young man, and his finances are limited. If the court would consider pretrial for him, I'm sure we'd have no problem getting him back to court to address these matters.
Well, I will just say from the outset, I understand his priors are somewhat limited, but based on the level of violence that's been alleged in the probable cause affidavit, I'm not gonna be comfortable with giving him a straight ROR to pretrial. James, you're here as his bondsman. Is there any additional information that you want to provide, or are you just here to observe?
Yes, ma'am. Judge, I'm sorry. This time I'd ask the court to swear in the witness.
Do you swear or affirm to tell the truth?
I do.
Thank you, and please just state your name.
James Jones.
Thank you.
I did speak with his mother, who she was currently at the doctor. She has recently had surgery. She's only able to come up with $250 most.
All right, at this time, bond will be set at $5,000. There will be an order of no victim contact. Mr. Nicholson, so that you understand the no contact order, that means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
All right, thank you very much.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
I have, I'm not sure if he's going to be present because he's toward the end of our docket, but if he is present, I have family signed in on Javaris Williams. He's on page 30. I believe he'll be at name.
Let me see. Javaris Williams? No, he's not here. I'll inform the deputies.
Okay.
Can you bring Javaris Williams on page 30?
All
Page
right.
30.
Just let me know whenever he's ready. And
I will,
there's
Judge.
Mr. Shate, perfect timing.
Shade.
All right.
Oh, there's
So-
Stephen Shade.
There he is. All right, so
Very
let's,
mysterious, Mr. Shade.
all right, so if I have these individuals, we'll address our municipal ordinances now. The first on my list is Brittany Ferry on page 3.
Judge, Your Honor may recall yesterday,
Yes.
she was here for a 30-day motion.
I
The
do.
state indicated they were going to drop the new charges. I guess these
That's correct.
popped up when she was being released.
Yes. All right, good morning, Miss Ferry.
Good morning.
Miss Ferry, you're here this morning on 2 ad charges. These are both misdemeanor capiases for municipal ordinance violations. They both relate to lodging on city-owned property. Do you want to resolve those cases today, Miss Ferry?
They're both time served. They're both would be time served offers.
Yes.
Okay, do you want to accept the adjudication time served offer?
Yes.
Okay. Miss Ferry, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you, and now you can put your hand down. Miss Ferry, do you understand what we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Sometimes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, Ms. Ferry? Guilty or no contest?
Guilty.
All right, I accept your plea and I find that it is freely and voluntarily given. Your sentence as to both of these charges will be an adjudication, time served. Good luck to you, Ms. Ferry.
Thank you.
You're welcome. Okay, next on page 3 also is Vera Delaney.
Those are both time served, Judge.
Okay, which,
North Brown.
thank you. Good morning, Ms. Delaney. Ms. Delaney, you're before the court this morning on 2 charges. These are both misdemeanor capiases, therefore municipal ordinance violations. Both are related to open container. I find probable cause. And Ms. Delaney, your attorney, Mr. Shade, is present here in the courtroom with me. If you want to resolve your cases today, then the offer from the city would be an adjudication, time served.
That would be fine with me.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, now you can put your hand down. And Ms. Delaney, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
Yes.
Someone is forcing you to resolve your case?
No, I'm sorry. I couldn't understand the question.
That's okay. I'm just going to ask it one more time, okay? Is anyone forcing you to resolve your case?
No.
Okay.
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter? Guilty or no contest?
No contest.
All right, Ms. Delaney, I accept your plea and find that it's freely and voluntarily given. Your sentence on both charges will be an adjudication, time served. Good luck to you, ma'am.
Thank you.
You're welcome. All right, on page 4, Kristen Swindell.
North Broward, I believe, Judge.
Okay,
North Broward, Your Honor.
thank you.
You're welcome.
Good morning, Ms. Swindell. Ms. Swindell, you're before the court this morning on 3 charges. The first is not for magistrate. It's a civil writ of arrest. That's from the Department of Revenue and has an $815 purge amount. There are also 2 misdemeanor capiases. Those are one is for a municipal ordinance violation for open container. The other is a state charge for prostitution. I find probable cause, and I have both of your attorneys are present in the courtroom with me. So, gentlemen, what do we want to do on Ms. Swindell's cases?
For the municipal ordinance violation, that would be a time-served offer.
Okay.
Okay.
And, Mr. Linder, is there an offer on count 3, which is the prostitution charge?
You withhold court cost HIV test.
All right. So, Ms. Swindell, a couple things I want to tell you. Number 1, with regard to the civil writ of arrest from the Department of Revenue, I have no
Yes.
control over that, okay? So no matter what we do today, that's still going to remain in place. You understand that?
Yeah, but who do I go to about that? My public defender or what? I don't understand what it is.
It is a civil writ of arrest from the Department of Revenue, and it has an $815 purge amount on it. So it's probably related to taxes.
Okay.
So now we'll talk about your other 2 cases, okay? The 2
Okay.
capiases. Now, if you want to
Okay.
resolve those 2 issues, then we can do that today.
Okay, I will.
All right, on the municipal ordinance case, which is the open container, the offer would be an adjudication, time served. Do you understand that?
Okay. Yes.
Okay, and on the state charge for prostitution, the offer would be a withhold of adjudication plus court costs, and there would be a requirement that you submit to HIV and STD testing within 30 days and provide not the results, but the proof of the test, meaning the receipt, to the clerk's office so that they know you did it. Do you understand that?
Yeah, do I have to pay for that?
Yes, ma'am.
I don't have the funds to do that.
Okay, well, you don't have to resolve it today. I'm just telling you, if you do want to resolve it today, that would be the offer.
Judge, there are places where she could have free service and have that done
Okay.
by the county.
Okay, so Mr. Shate, your attorney, is telling me there are places where you can go and get it done for free through the county.
Okay.
But it would have to be done within 30 days.
Okay. Well, what if I'm still in here for the writ?
Well, then, Mr. Linder, let me just ask you on that
Just,
front.
it just has to be within 10 days of her release.
Okay, so it would have to be done within 10 days of you being released, all right?
Okay.
Does that make
And,
sense?
yeah, and will that be withheld adjudication?
Yes, ma'am.
Okay, then I'll go ahead and do that.
Okay, so on those 2 cases, I'm gonna go ahead and ask you a few questions, and then we'll get those
Okay.
done. All right, will you please raise your right hand?
Yeah.
Do you swear or affirm to tell the truth?
Mm-hmm. Yes, I do.
All right, thank you. And now you can put your hand down. And Ms. Swindell, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorneys?
No, I don't.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Ms.
I
Swindell, what plea do you wish to enter? Guilty or no contest?
no contest.
All right, I accept your plea and find that it is freely and voluntarily given. So once again, your sentence as to count 2 will be an adjudication time served. Your sentence as to count 3 will be a withhold of adjudication plus court costs, and the requirement that you submit to the HIV/STD testing within 10 days of your release. And remember to provide the receipt, not the results, to the clerk's office
Okay.
as proof that you did it. You understand?
Okay, what about, community service for my court fees? Is that a possibility?
Yes, I would be inclined to let you do that. Let me just see. How, can you tell
Okay.
me, let me look with my clerk, how much are her total fees going to be? I think it's what, $293 on the state chart? $37 hours? All right, so Ms. Swindell, it would be 37 hours of community service. Do you think
Okay.
you would be able to do that?
Yeah, once I'm released, right, from jail, right? I get
So
like a year or 6
I
months
will,
or what?
I'll give you a year to do the service hours,
Okay,
okay? Think you can handle
Uh-huh.
that?
yes, I can.
Okay, all right, so then I'm gonna go ahead and put that on here, and you'll be good to go, okay? Good luck to you.
Okay, and
Thank
then I see somebody else about the writ,
Yes,
right?
ma'am, yes, you'll see somebody else about that.
Somebody will come see me here?
You'll probably get a court date for it, I would assume.
Okay, thank you.
Thank you, good luck. I did have, Mr. Shade, I had, you signed in for Renee De La Rosa, but,
There's no
he has no
paperwork.
paperwork.
Yeah,
Okay.
I wasn't sure.
All right, so the next on page 15, Joey Jackson. Which facility is he at?
He's in the main jail.
Thank you.
Approaching Judge, he's here at me.
Thank you. Good morning, Mr. Jackson. Mr. Jackson, you're before the court this morning on 2 municipal ordinance violations. These are for not having the appropriate safety vest or safety course. I find probable cause. Your attorney, Mr. Shate, is present in the courtroom with me. And Mr. Shate, what are we doing with Mr. Jackson's
It's a
case?
time served offer, Judge.
All right, so Mr. Jackson, if you want to resolve your cases today, the offer would be an adjudication time served. Do you understand that?
Yes, ma'am.
Do you wish to accept that offer?
Yes, ma'am.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
All right, now you can put your hand down, Mr. Jackson. Do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Mr. Jackson, I accept your plea and find that it's freely and voluntarily given. Your sentence as to both charges will be an adjudication time served. Good luck to you.
Thank you.
You're welcome. All right, next on page 16 is Chris Hilker.
Who did we just call, Judge? Mr.
Chris
Hennigan?
Hilker.
Oh, Hilker.
Mr. Hennigan is up next. All right, now we have Hilker.
He's approaching, man.
Thank you.
Right here, man.
Good morning, Mr. Hilker.
Lauren.
Mr. Hilker, you are before the court this morning on 4 charges. One is a municipal ordinance violation for disorderly conduct. Counts 2, 3, and 4 are capiases. Those are also for municipal ordinance violations. Those are for lodging on city-owned property, open container, and sleeping on a public street or sidewalk. I find probable cause. Your attorney, Mr. Shate, is present in the courtroom with me. And Mr. Shate, what are we doing with Mr. Hilker's cases?
Judge, due to the fact that Mr. Hooker hasn't been arrested in 16 months, they're willing to offer time served on all 4.
Well, that's very nice of them.
Right.
Mr. Hilker, if you want to resolve your cases today, then the offer would be an adjudication time served. Do you understand that?
Yes.
And Mr. Shade has told me the only reason that you're getting that offer is because you've gone 16 months without getting arrested. Do you understand that?
Yes.
All right. Do you wish to accept that offer today?
Yes.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and now you can put your hand down. And Mr. Hilker, do you understand everything we've discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
Yes.
Is there anything about that illness today that impacts your ability to accept this plea?
No.
And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And Mr. Hilker, what plea do you wish to enter? Guilty or no contest?
It's time served, written and adjudicated.
It's an adjudication time served, but you have the option of entering a plea of either guilty or no contest. Which do you wish to enter?
Guilty.
Which one?
Guilty.
Okay, I accept your plea and find that it is freely and voluntarily given. So, Mr. Hilker, your sentence as to all charges will be an adjudication time served. Good luck to you.
All right, thanks.
You're welcome. Okay, and next up is Mr. Hennigan. He is on page 16.
Everybody that's finished, coming out here.
Nope, I need Mr. William Hennigan. This is not Mr.
Oh,
Hennigan.
Mr.
William
Hennigan?
Hennigan?
No.
Come on up, Mr. Hennigan.
Just call me that. See it there.
No. Mr. Hennigan.
No,
We're
we need
looking for William
Mr.
Hennigan.
All right. Good morning, Mr.
Yes, ma'am.
Hennigan. All right, Mr. Hennigan.
I thought we solved this already. I don't know why.
I thought we did too. I know we resolved the other ones, and this one popped up. This is
Yes, ma'am.
this is a capias for. Let's see what the charge is.
Panhandling again, Judge.
All right, this is for panhandling, and this was for a court date that was on January 30th, so a week ago.
You might,
What's the offer, Mr. Shade?
Judge, no.
I'd like to solve it if I
Hold
could.
on,
right,
was
hold
he
on.
in jail, Judge, when he missed his court
Well,
date?
I'm not sure. That's why I'm asking you. If he wants to resolve it today, then I would be inclined to let him because I know he was just here in front of me
I
not that
just
long
dealt
ago.
with him for a bunch of cases as well,
Yeah.
so they would normally not want to offer him because he's had more than 20-something arrests.
I'm well aware, Mr. Hennigan and
Yeah.
I know each other well from the South Satellite Courthouse.
Right, and I know him just as well, probably. Judge, but again, if that's the situation, then.
Yeah,
it'd
just
be time
based on this circumstance.
Right.
Okay, so Mr. Hennigan, I want you
Yes,
to
ma'am.
hear me loud and clear, okay?
Okay.
I am willing to let you resolve this case today, but that is only because I know you were just recently in custody and we resolved those other cases that you had. But remember, if you keep picking up cases, the city is not going to offer you plea offers to resolve them. Do you understand that?
I agree with that, ma'am.
Give the Hollywood PD some time off, okay? You've been keeping them busy. All right.
Yes, ma'am.
If you want to resolve this case today, then the offer would be an adjudication time served.
Yes, ma'am.
All right, do you swear or affirm to tell the truth?
I do.
Thank you, and now you can put your hand down. Do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
I thought it was done, but yes, it is.
Okay, all right, so no one's forcing you to resolve it, right?
No, ma'am.
Okay, are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yes, ma'am, I do.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given, so your sentence will be an adjudication, time served. And Mr. Hennigan, remember, you need to check with the clerk's office to see if you have any future court dates at South, because if you do have them and you're not showing up, then they're gonna keep issuing warrants, okay?
Yes, ma'am.
So please check to see.
I was told that this was the only one. I was ran, though.
All right, well, please just make sure that there are no future court dates, okay?
Yes, ma'am.
All right, thank you, good luck.
Thank you, officer.
All right,
Officer,
you're the officer today, Mr. Shea.
that's fine, Judge. I've been called worse.
Yes, ma'am. All right, next up is Fred Danzy on page 16. All right, good morning, Mr. Danzy.
Morning.
Mr. Danzy, you're here on 4 charges. These are each a misdemeanor capias for a municipal ordinance violation. The charges were for open container and lodging on city-owned property. I do see that these seem to be a little bit old.
Correct, Judge. Again, he hasn't been arrested
Too
since
old.
2018.
Yes.
2018, these were his only arrests in 2018. So
Okay.
we just unresolved.
All right, so is it an adjudication time served?
Correct.
All right, so Mr. Danzy, if you want to resolve these 4 charges today, the city's offer will be an adjudication time served. Do you understand that?
Yes, ma'am.
All right, do you want to accept that offer today?
Yes, ma'am.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
All right. And Mr. Danzy, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
I understand.
Have you ever been treated for a mental or emotional illness?
Ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. Your sentence as to all 4 charges will be an adjudication, time served. Good luck, Mr. Danzy. Okay, next up is Matthew Higgins on page 18.
No, he's, no problem, ma'am.
Thank you.
North Broward, Your Honor.
Thank you, Deputy.
Come on, you got it.
Good morning, Mr. Higgins.
Good morning.
Mr. Higgins, you're before the court this morning on a misdemeanor capias. This relates to a municipal ordinance violation for trespassing. For the record, I find probable cause. I have your attorney, Mr. Shate, present with me in the courtroom, Mr. Higgins. And Mr. Shate, what are we doing in Mr. Higgins' case?
It's a time served offer, Judge. It appears this is the only arrest in Broward County.
Okay, so Mr. Higgins, if you want to resolve the case today, the city's offer is an adjudication, time served. Do you understand that?
Yes, ma'am.
Okay.
Yes, Your Honor.
Do you wish to accept that offer?
Yes, ma'am. Yes, Your Honor.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am. Yes, Your Honor.
Okay, now you can put your hand down. And Mr. Higgins, do you understand everything we've discussed here today?
Yes, ma'am. Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, ma'am. No, Your Honor.
Are you under the influence of drugs or alcohol?
No, ma'am. No, Your Honor.
Do you need any more time to speak with your attorney?
Oh, no, ma'am. No, Your Honor.
Okay. Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am. Yes, Your Honor.
Have you ever been treated for a mental or emotional illness?
I have PTSD and ADHD.
Okay.
And, mood disorder, but I've been taking my meds for about 3.5 weeks now.
Okay.
Except for last night, I had a little slip up with pardon the slang, with the alcohol.
Okay, well, let me ask you this. Is there anything about any of those illnesses that impact your ability to accept this plea today?
No, ma'am. No, Your Honor.
Okay. All right. And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am. Yes, Your Honor. I understand.
Okay. And what plea do you wish to enter, Mr. Higgins? Guilty or no contest?
Guilty.
Okay.
Guilty, Your Honor.
All right. I accept your plea and find that it is freely and voluntarily given. Your sentence as to this charge will be an adjudication, time served. Good luck to you.
Oh, thank you. You too.
All right. Next will be Nicholas Ramsey on page 18.
Thank you.
Thank you. Good morning, Mr. Ramsey.
Good morning.
Mr. Ramsey, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for open container. I find probable cause. Your attorney, Mr. Shate, is in the courtroom with me. And Mr. Shate, what are we doing with Mr. Ramsey's case?
It's time served, Judge.
All right, Mr. Ramsey, if you want to resolve the case today, the offer's an adjudication, time served. Do you understand that?
I do.
Do you wish to accept that offer?
Yes.
All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
I do.
All right, and now you can put your hand down. And Mr. Ramsey, do you understand everything we've discussed so far today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No, I don't.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
I understand.
Have you ever been treated for a mental or emotional illness?
No, I haven't.
I'm sorry?
No, that was a no.
Okay, all right. Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Mr. Ramsey, I accept your plea and find that it's freely and voluntarily given. Your sentence in this case will be an adjudication, time served. Good luck to you. All right, are there any others?
That's it, Judge.
Did you double check the docket? It's a big one today.
I went all the way through it.
Okay.
Yes, ma'am, yes, Your Honor, I did.
Thank you, Mr. Shea.
Take care.
All right. Let me just ask one more time before I start going down the list. Is Mr. Javaris Williams present at Maine yet?
He is, Judge. I apologize.
Okay, no, that's
Come on
all
up,
right.
Mr. Williams.
Okay, so he does have family present in the courtroom. Okay, good morning, Mr. Williams.
Good morning.
Mr. Williams, you're before the court this morning on 4 charges. Count 1 is for fleeing or eluding law enforcement while lights and sirens are active. 2 is driving while license suspended, first offense. 3 and 4 are each felony probation violations, which have no bond holds. I do see you have hearings before your division judges on those matters tomorrow and on Monday. For the record, I find probable cause, and let me just see, who's present on Mr. Williams' case? Ma'am, are you just here to observe? You come on over to the podium. Okay. So just tell me if were you here to observe or to speak?
I was here to speak a little bit.
Okay, so that's all right. So hold on. Let me just tell you the same thing I tell everybody, which is that everything that we say is being recorded and can be used against you and potentially him at a later date. Do you understand that?
Yes, ma'am.
All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
And will you please state your name and spell your last name?
Courtney Johnson is Johnson.
All right, Ms. Johnson, what is it you would like to tell us today?
I was just coming to provide you guys with a document, a notarized letter. I have a witness stating that it was not him driving the car. You know, we've been harassed by this officer many times, and he's also stated that every time he sees the car, he's going to pull it. I don't necessarily know what happened that day because I was at work, but I was informed that the car was running hot and my brother was driving the car. And my mom did state that she would come in and testify, her and my brother. So I guess I don't know if that's going to be tomorrow in front of Judge Al Spector or Monday in front of the other judge.
Yes, so I understand everything you're telling me. What I want to say to you at this point is that for today's purposes, I'm just going to be addressing bond and release conditions.
Okay.
Anything that goes to the facts of the case can be discussed with his attorneys and his division judge
Okay.
following today. Okay?
Okay.
Does that make sense?
Yes, ma'am.
Okay. All right. So at this time, I will hear from the attorneys with their recommendations for bond and release conditions.
Your Honor, I'm asking that the bond be kept in place in light of the no bond VOP holds.
Okay. Mr. Romero?
And Judge, I spoke with Mr. Williams. I know his girlfriend is there with important information. I did advise Mr. Williams he signed up with the public defenders to try and relay that information to his attorney so then it can make its way up to hopefully the case filer. But at this time, he has a no bond hold. Nothing to add. He just wants to his girlfriend to know that he has a court date tomorrow morning at 8:30 in the morning.
Okay. All right. So in light of that, the bond on count 1 will remain in place. And as stated, Mr. Williams will see his division judge tomorrow morning. All right. Thank you very much. Okay. So now I'm going to start on our regular stack here. I'm not sure if at any point we're going to have an interpreter on cases, but for now I'll just start going in order. Next up will be Kathleen Vukmanich.
North Broward, I believe, Judge.
Thank you.
That's correct. North Broward, Your Honor.
Thank you. Good morning, Ms. Vukmanich.
Good morning.
You are before the court this morning on 2 charges. Count 1 is for battery on a person 65 years of age or older. 2 is for resisting an officer or obstructing without violence. I find probable cause, and I will hear from the parties.
Defer to
I'm
the state.
requesting a $2,500 bond, no victim contact. Based on the level of violence, statements made by the alleged victim to law enforcement, her history, I only have access to Broward history. I don't know if there's anything elsewhere. She has a DUI 2009, battery 2009.
Anything else?
No.
All right, Mr. Miller?
Yes, ma'am. Judge, I spoke with I spoke with the defendant earlier this morning. She is a lifetime resident of South Florida. She's returned in December to the place where she has lived for the past 10 years. She's currently unemployed. She's relying on family to help support her. She is a registered voter, and she does advise that she will have a place to live that is separate and apart from the alleged victim. A 10-year-old or 11-year-old now battery case. I don't know how that was resolved. However, I would ask the court to consider pretrial release for her.
Okay, at this time, I'm going to set her bond at $1,500. There will be an order of no victim contact. Ms. Vukmanich, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Sure.
Okay, all right, thank you very much. Yes, ma'am.
I'm not quite sure what happened, so I have a bond set for $1,500, and
Yes,
that's
ma'am.
in order for me to get out?
That's correct. That's correct.
Okay. All right, thank you
All
very
right,
much.
thank you. Shakia Holloway,
She's here, President Judge at Maine, approaching. Come on up, ma'am.
thank you. Good morning, Ms. Holloway.
Good morning.
Ms. Holloway, you are before the court this morning on 2 charges. One is a misdemeanor capias The other is a felony violation of probation. That has a no bond hold. I find probable cause. I do see that Ms. Holloway is scheduled to go before her division judges. The VOP is scheduled for tomorrow morning, and she has a status hearing in the misdemeanor matter on Monday. Do the parties wish to be heard?
No, Judge.
Not at this time, Judge.
All right. The bond will remain in place at this time, and she'll see your division judge tomorrow. Thank you. Natalia Johnson.
She's approaching, Judge. She's here at Maine. Come on up, Ms. Johnson.
Good morning, Ms. Johnson.
Good morning.
Ms. Johnson, you're before the court this morning on a misdemeanor capias. This relates to a charge for trespassing. You find probable cause, and I'll hear from the parties.
Judge, after speaking to Ms. Johnson this morning, she wishes to resolve this matter. We wanted to see if the state had a plea offer for her.
Offers adjudication, court cost, no return to Inverary Village at 2977 Northwest 56th Avenue in Lauderhill.
Judge, Ms. Johnson wishes to accept the state's offer.
All right, Ms. Johnson, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak to your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Ms. Johnson, your sentence will be an adjudication, time served, and there will be the no return order that we discussed. Do you understand that?
Yes, ma'am.
All right, thank you very much.
Good luck, ma'am.
Thank you.
Yeah. Second and third.
Next will be Augusta Ellis.
She's here present, Judge of Maine.
Thank you. Good morning, Miss Ellis.
Good morning.
Miss Ellis, you're before the court this morning on 3 traffic capiases. These relate to charges for an unlawful license tag or sticker, driving with a suspended license, and the third is also for driving with a suspended license. I find probable cause, and I'll hear from the parties.
Judge, after speaking to Ms. Ellis, she wanted to try and resolve these offenses, so we wanted to see if the state had a plea offer for her.
I'd offer an adjudication, time served, but this would be your second and third within a 5-year period, and she does face the possibility of having her driving privileges revoked for 5 years.
I explained that to her, but let me explain it once more. Judge, I did explain to Ms. Ellis as far as what the state informed us of, and she wishes to accept the state's offer.
All right, the offer is an adjudication, time served.
Yes, Judge.
All right. Miss Ellis, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and now you can put your hand down. And Miss Ellis, do you understand everything that's been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak to your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes.
And what plea do you wish to enter, guilty or no contest?
No contest.
All right, Ms. Ellis, I accept your plea and find that it's freely and voluntarily given. Your sentence as to these charges will be an adjudication, time served. Good luck to you. Tangelise Vickers.
She's approaching, Judge, here at Maine.
Thank you. Good morning, Ms. Vickers.
Good morning.
Ms. Vickers, you're before the court on a charge for felony battery. I find probable cause, and I'll hear from the parties at this time.
One moment, Judge. Your Honor, she's not in my database. It's gonna take me a moment to enter her information.
All right, Mr. Romero, do you want to go first?
I will, Judge, and speaking Ms. Vickers, she did advise me, she has priors, mostly traffic-related offenses. Been speaking to her, Judge, she's 26 years old. She is a single mother raising her 4-year-old child. Right now, her child is with the child's grandmother, her mother. They live locally here in Fort Lauderdale, or they rent, they do not own. She's an entertainer, Judge. My understanding is I'm going to be contacting a friend of hers to help post her monetary bond. My understanding, in speaking Ms. Vickers, as far as the friend's financial resources, they're limited. So I'm going to be asking on her behalf for a $2,000 bond. And that's what we're requesting for at this time, Judge.
And Judge, I would just ask the court to keep in mind that this is a case that stems from an incident that occurred in June, and this is a not in custody information that was filed against this defendant.
I'm aware of that, but the allegations that are in this probable cause affidavit are obviously very serious.
That is correct. And just one other note, Judge, allegedly, I know this incident happened in June. I don't think there's been any sort of contact since then. So obviously, the court's going to impose a no contact order. So I believe that additional fact should put the court at ease as far as the contact order.
Your Honor, I'm going to be requesting the $7,500 bond, no victim contact. Considering the injuries that the victim has suffered in this case, fractured nose, multiple contusions and lacerations to her face, and a deep laceration to her leg that required surgery. Additionally, I'm showing Ms. Vickers has an outstanding warrant out of the state of Georgia for failing to appear in court. That's from March 29th of 2018. I'm also showing she was arrested in 2018 in St. Lucie County on another failure to appear. Not showing anything else, Judge.
All right, her bond will be set at $5,000. There will be an order of no victim contact. Ms. Vickers, so that you understand the no contact order, that means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, ma'am?
Yes.
All right, thank you. Samantha Simmons,
I believe North Broward.
thank you.
North Broward, Your Honor.
Thank you very much. Good morning, Ms. Simmons.
Good morning.
Ms. Simmons, you're before the court this morning on 4 charges. Count 1 is for possession of fentanyl, 2, possession of cocaine, 3, possession or use of drug paraphernalia, 4 is a seatbelt violation that is not for magistrate. I find probable cause, and I will hear from the parties at this time.
Refer to the state.
I'm not asking for anything.
Right.
Judge, we're going to ask for pretrial release for this defendant for these nonviolent charges. She is a lifetime resident of South Florida, living at the same address, graduate of Deerfield High. She does live with her family. She does have 4 dependent children who are currently with their father and the grandparents. She is an unemployed food server, relying on her family for support. We would ask the court, again, for pretrial release for her if there's nothing
In her history.
in her
Does
past.
she have any priors?
She does, Your Honor. I'm not really concerned about that. If the court could inquire what specific address she resides at.
Ms. Simmons, where do you live?
714 Northwest First Way, Deerfield Beach.
All right.
I don't have an objection to pretrial with random testing, Judge.
All right. So, I will grant the request and I will ROR Ms. Simmons to pretrial supervision. Ms. Simmons, a couple of things that you need to know, okay? I'm
Yes.
going to release you to pretrial supervision. You will get some information from the deputies before you are released. You must report to pretrial supervision within 24 hours. If you fail to report as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes.
All right, additionally, as a condition of your release, you will be subjected to random testing. That means no alcohol, no intoxicants. Do you understand that? Did my screen just freeze? Yes.
Everybody just froze. We're all dead. Hey, yeah, it froze over here too. They're gonna reset it. Thanks.
Please call Craig.
And Judge, I'm gonna ask for, a waiver, just in an abundance of caution.
That's fine. All right, I'm gonna go ahead and put us off the record for a moment while we get this fixed. All right, can you hear me at Maine?
I sure can, Judge.
All right, let's keep our fingers crossed that our feed stays intact. Next up will be Stephanie Bryant.
North Broward, Judge.
Yes, on the last case for Miss Simmons, I did put on the finding sheet there will be a 30-day waiver. All right, did you say North Broward for Bryant?
Yes, correct.
Okay, thank you.
Yeah.
All right, good morning, Miss Bryant.
Good, how are you?
I am well. Miss Bryant, you're before the court on 7 charges. Count 1 is for possession of fentanyl, 2, possession of heroin, 3, 4, and 5 are separate counts for possession of a controlled substance without a prescription. Counts 6 and 7 are each a separate count for possession or use of drug paraphernalia.
Judge,
Yes.
I do have an argument as to count 6 and 7.
All right.
I've read the probable cause affidavit, and I may have missed it, but it didn't appear that the alleged paraphernalia was tested.
Your Honor,
Yes.
she made an admission that she had used her drug of choice a few hours earlier, that the spoon, needle, and pills were hers.
I did not
That-
say that.
Miss Bryant, I would just advise you to remain silent at this time, please. I'm hearing from the attorneys.
Okay.
Thank you.
There was a clear pipe with Brillo pad in it, and that the officer mentions it appears to have been used due to residue and burn marks. Based on the totality of the circumstances, I believe the officer has probable cause to believe this is drug paraphernalia.
All right, well, I do understand Mr. Miller's argument with regard to the testing. Based on the totality of everything I'm seeing in the probable cause affidavit, I do believe that we have enough for a probable cause finding for today's purposes. So I will make a finding of probable cause for the charges that are before the court this morning. And at this time, I'll hear from the parties as to their recommendations.
Sure.
Asking for the bonds to be kept in place.
Okay.
Judge, Ms. Bryant is a lifetime resident of South Florida. She just moved, but prior to moving, she was at her previous address for about a year. She's currently unemployed, and she relies on her boyfriend for support. She does work in real estate, construction, housekeeping, that sort of thing, and she is looking for work. She advises she is a registered voter. She's going to be relying on her family and children to bond her out. Inasmuch as these are non-violent charges, I would ask the court to consider pretrial release for her on this matter.
She's been on pretrial before?
Yes.
When was that?
Huh? I'm sorry?
Not Miss Bryant, I'm asking somebody here in the courtroom. One moment. December 2016? Okay.
Not object, Your Honor, to random testing, but we would ask for a waiver if the court grants our motion, our request.
Is there an automatic 30-day waiver on their testing? All right, Mr. Linder, does she have priors?
She does, Your Honor. I'm curious to know where she resides because the report indicates that she's homeless.
Ms. Bryant, where are you living right now?
I just moved from Broward County to North Miami. I'm staying with my boyfriend there right now.
Do you know
until
the
we find a
address?
place. 16700 Southwest 21st Avenue.
Okay, is that a house, an apartment? What is it?
Apartment. That's North Miami.
What's your apartment number?
22.
Okay.
They can. I would have no objection to pretrial with random testing if there's verification.
Okay. All right, so here's what I'm going to do, Miss Bryant. If pretrial supervision can verify your address before you're released, then I will release you to pretrial supervision, but you will be subjected to random testing. That means no alcohol, no intoxicants.
Okay.
All right. That also means that you'll have to report to pretrial supervision within 24 hours. If you don't
Okay.
report to them as I've instructed, then a warrant will be issued for your arrest. Do you understand that?
Yes, I do.
All right. Additionally, because I did say this is pending verification of the address, if they are not able to verify the address, then the standard bonds will remain in place for the time being. Do you understand
How do
that?
they verify the address, if I can ask?
Well, we can either go to the residence, that address that you gave us. If it's a real address, we'll go there and verify it.
Okay.
Or we'll contact someone, we'll call you to
All right.
get information.
They will either call you at the jail to get contact information for someone that they can call, or they will physically go to the address to verify that it is the correct address.
Okay.
All right?
Okay, thank you.
Okay, all right, thank you very much.
Just to repeat that address again. 16700 Southwest 21st Avenue, apartment 22 in North Miami Beach.
Thank you, Patrice. Next will be Irene Allen.
North Broward, Judge.
Thank you. Good morning, Miss Allen. Miss Allen, you're before the court this morning on a charge for driving with a suspended license, third or subsequent offense. I find probable cause, and I'll hear from the parties.
And from the state.
Judge, we're going to be seeking pretrial release for her. As you can see from the probable cause affidavit, these suspensions themselves are rather dated. Ms. Allen advised me she's attempting to fix her license. However, apparently there's some $6,000 in interest that's causing her some grief. She is a 25-year resident of South Florida. She says she's been living at the same address for the past 5 years. She's currently receiving disability.
I have no objection to pretrial.
Thank you.
All right, Miss Allen, I'm going to RR you and release you to pretrial supervision. A couple of
Yes,
things
ma'am.
that you need to understand. One is you are going to get some information from the deputies before you're released. You
Yes,
must
ma'am.
report to pretrial supervision within 24 hours. If you fail
Yes,
to
ma'am.
report to them, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, ma'am.
Additionally, Miss Allen, I'm just going to advise you that I understand what Mr. Miller has told me, that some of these suspensions appear to be dated, and you may be having some difficulties with the financial issues, but if you don't have a valid license, you are not to be driving. Do you understand that?
I understand, ma'am.
All right.
I made a mistake.
All
but
right,
I had-
that's
I had-
okay. I don't want you to, don't comment on it, don't comment on it,
Okay.
okay? I just want to make sure you
Okay.
understand, okay?
Yes, ma'am.
All right, thank you. Good luck.
Thank you.
Ada Mendez.
Judge, Ms. Mendez is at North Broward. However, I've been advised that she refused to come to court this morning.
All right. So are we going to reset her?
Your Honor,
Yes.
let me just check one thing. I have no objection to an ROR on count one.
Okay. What are we doing with count two?
There's no bond attached to it.
So she'll be released?
Yeah, if she's ROR on count one, yes, she will be.
All right.
Thank you, Mr. Linder.
AC Stewart.
Maine.
Thank you.
Stewart is approaching. Judge, my understanding, Judge, is I believe she declined the public defender. She's her family's going to hire private counsel on her behalf.
Thank you. Ms. Stewart, do you understand that you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am.
And are you declining the services of the public defender at this time?
Yes, ma'am.
All right, for the record, Ms. Stewart, you're before the court this morning on 2 charges. Count 1 is for grand theft greater than $750, less than $5,000. Count 2 is a felony probation violation, which has a no bond hold. I find probable cause. And, Mr. Linder, are you seeking anything in addition to the standard bond?
No, Judge.
All right, so the standard bond of $1,000 will remain in place on count 1. And Ms. Stewart, you'll be going before your division judge shortly to address the violation of probation issue. Good luck to you.
Oh,
Jada Daniel,
Judge, she bonded.
all right,
David Daniel.
Ms. Rojas, come on up.
thank you. Natasha Rojas,
She's here present, Judge Amain.
thank you. Good morning, Ms. Rojas.
good morning.
Ms. Rojas, you're before the court this morning on 2 charges. Count 1 is for grand theft greater than $750, less than $5,000. 2 is for having an unsecured or obscured tag. That count is not for magistrate. I find probable cause. I'll hear from the parties if they wish to be heard.
Judge, yes. And speaking of Ms. Rojas, I believe she has a clean record. She's 18 years old, been here her whole life. Right now, she's enrolled currently at Sunfire High School, where she's in a program trying to make up credits in order to graduate this year. She lives in Sunrise with her mother. If the state can verify that she has no prior record, I'm going to be asking the court on this nonviolent offense to consider a straight ROR. If the court does not feel comfortable, then I'd ask you to leave the bond in place so I can contact her friends and family to post her monetary bond.
Mr. Romero, did you say that she is in high school right now?
She's enrolled at Sunfire High School, which is an alternative school in order to catch up with your credits.
Okay. All right, Mr. Linder?
I'm showing that there was an arrest August 20th of 2018 on a probation violation at a Sunrise. And then she was also picked up September 15th of 2018 on a failure to appear. I'm not certain what those are connected to. I think, yeah, they were attached to juvenile cases.
Judge, in that case, I'd withdraw my request for straight ROR. Just leave the bond in place. I'm going to be contacting your family post your bond.
All right, the standard bond will remain in place at this time. Thank you. Chester Buchanan,
Who's this?
Judge, recall.
okay. Nick Lowell,
Nick Lowell is here present, Judge Amain. He's approaching. Mr. Lowell.
thank you. Good morning, Mr. Lowell.
Good morning.
Mr. Lowell, you're before the court this morning on 2 charges. Count 1 is for battery causing bodily harm, domestic violence. 2 is for tampering in a misdemeanor proceeding. I find probable cause, and I'll hear from the parties.
Judge, my understanding is Mr. Lowell has a clean record. He was arrested before. However, my understanding it was dropped. Now he's a registered voter in our community. He's 34 years old. He's been living here since 2013. He will be living separate and apart from the alleged victim. Right now he is not working. He's currently looking for employment. The only person that's going to be able to help post his monetary bond is his father. And my understanding is he's an Uber driver. So I'm respectfully going to be asking for a $1,000 bond on each count.
Your Honor, the arrest that Mr. Romero is referring to was a 2017 domestic violence battery. 2 counts. One of the counts is against the same alleged victim as in this case. The other count was against a different alleged victim. The charges were dropped. Our office has had contact with the alleged victim, and she has advised us she is in great fear of Mr. Lowell to the point that she has moved out of the home to a shelter because she is so concerned about Mr. Lowell knowing where she is. I would also note it would appear that at least part of this incident occurred in front of the victim's child. Your Honor, I'm going to be requesting a $5,000 bond on each count, pretrial release of the GPS monitor, no victim contact.
Judge, just to remind the court, this incident is said to have occurred back in January of this year, and there have been no or Mr. Linder's not reporting any additional incidents or any attempt by Mr. Lowell to contact the alleged victim in this case.
And that's why I brought up, Your Honor, the information the alleged victim provided. She took proactive measures to specifically ensure that Mr. Lowell could not locate her.
And Judge, just to give the state the benefit of doubt, those proactive measures seems to be working, so therefore, he isn't having any sort of contact, as you heard, he does have a clean record.
Mr. Romero, I'm just gonna stop you right there, okay? I appreciate what you're saying to me, but do not come to this court and tell me that because an alleged victim has removed herself from a home and put herself in a shelter so that this alleged defendant does not know where she is, does not give him the benefit of saying he hasn't had any contact with her. Nothing further. Bond on count 1 will be set at $5,000. Bond on count 2 will be set at $1,000. If Mr. Lowell does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact in this case. Mr. Lowell, so that you understand, that means no being in the same place at the same time. Since you will be on a GPS monitor, that does include a 500-foot stay-away order from the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, I have
Thank
one
you.
question though.
One moment.
Yes.
Judge, his question, I think I've answered it. The court order that the court has put in place as far as no contact with the alleged victim.
Correct.
Not no return to the home. As the court pointed out, she left. So if she's not there, he's allowed to return. And that's what I was informing him of.
Yes, as long as she is not there and she is in fact gone from the home, then he can be there. All right, thank you. Latravis Curry.
He's here.
Thank you. Good morning, Mr. Curry.
Good morning, ma'am.
Mr. Curry, you're before the court this morning on 2 charges. Count 1 is for domestic battery by strangulation. 2 is for touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties.
Does pretrial have any history for Mr. Curry? I don't mind.
Mr. Romero, you want to go first?
No, I do not.
Okay. Young County? Kidnapping and battery?
Another charge of domestic battery in 2013. 2012, battery with prior conviction.
No. Mr. Linder?
Based on his criminal history, Your Honor, and the level of violence in this case, excuse me, I'm requesting a $10,000 bond on count 1, $2,500 bond on count 2, no victim contact.
Judge, from what the state has requested, $12,500, that's something that Mr. Curry does not have. Right now, he's working a labor pool. When there's work, anywhere from $60 to $80, that's all he gets. He's 41 years old. He will be living separate and apart from the alleged victim. He has a cousin that lives in Palm Beach that he's going to be reaching out to see if his cousin can help him through this difficult time. However, his financial resources are quite limited. Judge, I'm going to be requesting a $3,000 bond on count 1 and a $2,000 bond on count 2, a total of $5,000 on Mr. Curry's behalf, and I'm going to be asking for a photo order as well.
All right, I'll sign the photo order. Bond on count 1 is going to be set at $7,500. Bond on count 2 will be set at $2,000. There will also be an order of no victim contact. Mr. Curry, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
Thank you. Jonathan Bose.
Mr. Bose is here present, and Judge, whenever the court's ready, Mr. Buchanan is back.
Okay, I'll take him next, after Mr. Bose. All right, good morning, Mr. Bose.
Morning.
You're before the court this morning on 2 charges. Count 1 is for violation of an injunction for protection, domestic violence. 2 is for a felony probation violation, which has a no bond hold. I do see Mr. Bose has a hearing before his division judge on the VOP matter tomorrow morning. I find probable cause for these charges, and I will hear from the parties.
Your Honor, I'm going to be requesting a $50,000 bond on count 1, pretrial release with a GPS monitor level 1, should he become eligible for release on this case at some point, and no victim contact. Your Honor, frankly, just the allegations themselves are concerning enough that he would ignore a court order, violate a court order, having contact with his victim, but then to go so far to actually try to essentially have this victim's child taken away from her because of whatever issues he has with her. And as the arresting officer states, he was at that home. He saw that home. None of the alleged complaints that Mr. Bose raised to Child Protective Services exist. So that he'd be willing to go that far is reprehensible. But on top of all that, Your Honor, he was just released from state prison August 16th of 2018 from a 2016 domestic violence case where he was convicted of strangulation and 2 count of domestic violence battery, felony battery due to priors. He was sentenced to 31.5 months state prison as a habitual offender to be followed by probation, and that's the basis for his VOP. In 2014, he was convicted of felony battery due to priors, and the alleged victim in that case is the same victim as in this case. He violated his probation and was sentenced to 364 days in county jail. In 2012, he was arrested for violating an injunction that was dropped. In 2012, he was arrested for domestic violence battery by strangulation, child abuse, felony battery due to priors, and criminal mischief. Those charges were dropped. 2011, he was convicted of battery, and that was domestic in nature. And in 2011, he was convicted of aggravated battery against a pregnant victim. He violated probation sentenced to 150 days in county jail. So there, Mr. Bose clearly has a lengthy history of violence against women.
Thank you. Mr. Romero?
Judge, 50,000 is something Mr. Bose is not going to be able to afford. He's a cook at a local restaurant. Financially, he can't afford that. But I do realize he has a no bond hold. He's going to have to go in front of his division judge to seek some sort of relief. We're asking for $5,000 on count one.
The bond on count one will be set at $25,000. There will be an order of no victim contact. That should go without saying, given the fact that there is an injunction in place regarding the alleged victim in this case. But Mr. Bose, I'm going to say it once again, no victim contact means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
All right, you'll be seeing your division judge tomorrow morning to address the VOP. Good luck. Yes?
Your Honor, as far as the pretrial request?
Oh, I apologize. Will you bring Mr. Bose back for one moment?
He's returning.
All right, Mr. Bose, I'm sorry, I left out some information. In addition to the monetary bond, if you do become eligible for release, depending on what happens with the violation of probation, and you post the monetary bond for the case that's before us today, then you will be placed on pretrial supervision. I'm not going to order a level 1 GPS monitor, but I will order a level 2 GPS monitor. Mr. Bose, so that you understand, since you will have the GPS monitor, that includes a 500-foot stay-away order from the alleged victim. Do you understand that?
Yes, ma'am.
Thank you. All right. Thank you. Okay, next will be Chester Buchanan.
He's here, President Judge Jermaine.
Thank you. Good morning, Mr. Buchanan. You're before the court this morning on 2 charges. Count 1 is a warrant for a violation of pretrial in a felony case that has a no bond hold that is not for magistrate. And count 2 is an out-of-state felony hold that's out of the state of Mississippi, which also has a no bond hold. I find probable cause for these charges. And Mr. Buchanan, you'll go before your division judge to deal with the violation of pretrial. And with regard to the out-of-state hold from Mississippi, you'll go before the extradition judge to address how that matter will be handled. Good luck to you. Next will be Roy Roberts.
Mr. Roberts is approaching. Come on up, Mr. Roberts.
Thank you. All right, good morning, Mr. Roberts.
Morning.
You're before the court this morning on 4 charges. Count 1 is for aggravated stalking, domestic violence. 2 is for aggravated stalking after an injunction for protection, domestic. 3 is for contempt of court where an offender has violated a no contact order. And 4 is for using a 2-way communication device to facilitate a felony. I was provided with a supplemental report in this case, so let me just take a look at that. One moment. find probable cause, and I will hear from the parties.
Your Honor, I'm going to be requesting a $15,000 bond on count 1 and count 2. Order of no victim contact, pretrial release of the GPS monitor. While Mr. Roberts has no history, I would note the strength of the evidence against him. The GPS tracker that was taken from the victim's vehicle, based on the detective's investigation, it was learned that that tracker was subscribed. It was obtained by Mr. Roberts. He subscribed to the service where the GPS tracker was obtained from. He also, it is logical and reasonable to conclude that he sent the encrypted text messages to the victim, telling her, all the locations she traveled to during the day, including a picture of a location she was at earlier. It would make sense that the person that put the GPS monitor that would have that information, knowing where she's been all day. But it's not that just he knew where she's been all day. Clearly, he was following her if a picture was taken. It's also quite coincidental, Your Honor, that the day law enforcement and she discovered the GPS monitor, it was the subscription was deactivated. Violating an injunction is one thing. I can't imagine how much fear one must go through knowing that someone's following you and knowing where you are at all times and not even being certain who it is. I think these bonds and release conditions are necessary to ensure that Mr. Roberts will now take a judge's order to stay away from this woman more seriously.
Mr. Romero?
Judge, I didn't hear the monetary bond recommendation from the state.
It was $15,000 for count 1 and count 2.
Judge, I just informed Mr. Roberts as far as part of the state's recommendation. Judge, certainly from what he advised me right now, $30,000 is something he cannot afford. As you heard from the state himself, Mr. Roberts has a clean record. He's 32 years old. He's working. He's been working for the same company now for 6 years. He works at Pool and Patio Depot. He's living with his sister at North Miami Beach. My understanding is his share of the rent which he's been giving to his sister to help him out is $600 a month. That's the person's phone number that he gave me that I'm going to be contacting to help post his monetary bond. From what Mr. Roberts advised me, she's not going to be able to afford the $30,000. I'm going to be requesting a $2,000 bond on count 1, $2,000 bond on count 2, Judge, along with the other 2 bonds. That I believe a total $6,000 bond on Mr. Roberts' behalf.
Bond on count 1 will be set at $7,500. Bond on count 2 will be set at $7,500. The standard bonds will remain in place on 3 and 4. If Mr. Roberts does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Mr. Roberts, so that you understand, since I've ordered the GPS monitor, that will include a 500-foot stay-away order from the alleged victim in this case. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes.
All right, thank you. Thank you. Next will be Mark Forkand.
Medical reset.
Okay. Kevin Easton.
Conti?
Thank you.
Conti, Your Honor.
All right, thank you. Good morning, Mr. Easton.
Bless morning.
Mr. Easton, you're here on a change of charge. I just want to make sure this is correct. The original charge was aggravated battery causing bodily harm. This has been changed to aggravated battery with a deadly weapon. Is that correct, Mr. Linder?
Yes, it's still essentially the same offense, Your Honor. Bond was originally set at $2,500. I'm just asking that that bond be kept in place.
For the record, I do find probable cause. Mr. Miller, you have any objection to leaving the bond?
Mr. Easton advised me that the original bond was $1,000. I'm not in a position to argue either way.
That was on the, I believe that was on carrying concealed weapon, but I'll check again.
Okay.
Okay. Thank you.
It's 2,500 on this count? Okay, all right, the bond will be set at $2,500. All right. Thank you. Good luck, Mr. Easton. Brian Payette,
Also at Conti.
thank you.
Conti, Your Honor.
Thank you. Good morning, Mr.
Good
Payette.
morning. Good morning, Your Honor.
All right, Mr. Payette, you're here on a change of charge. I just want to say this was originally aggravated assault with a deadly weapon, domestic, and it's been changed to aggravated battery with a deadly weapon. Is that correct?
Yes, Judge. Technically, it has been upfiled. That being said, I reviewed the PC. Bond was originally set at $2,500, and I'm fine with it being kept at $2,500.
All right, for the record, I do find probable cause. Mr. Miller, you have anything you want to add?
Judge, I just, Mr. Fayette obviously has no one to bond him out at this time. He is a 12-year resident of South Florida. He's living in his previous address for about a month and a half. It appears he lives on disability, and it appears that the alleged victim in this case has all of his banking materials. So he can't get any money because she has his wallet. He can't bond himself out. So he's kind of in a catch-22 situation. He could afford to bond himself out. However, she's holding his ability to bond himself out. And so I would ask the court to take that into consideration. Maybe we can let him out on pretrial. I don't know what his priors are like or what his previous charges are, but it just seems like it's inherently unfair for the alleged victim in the case to control the keys to his jail.
First of all, considering that he allegedly cut her with a pair of scissors, I don't know that I would say that anything regarding the victim in this case is unfair. Secondly, Your Honor, I don't really think there should even be a bond review in this situation. The charge was upfiled. It's just a technicality that he's here.
Okay. All right, I'm going to leave the bond amount at $2,500 for the time being. All right, good luck, Mr. Payette.
Thank you, Judge.
Thank you, Your Honor.
Christopher Floyd.
Judge, he's at North Broward and apparently has refused to join us this morning.
Okay. Well, this is a capias, so do you have any objection to me proceeding without him?
I do not.
All right. In light of that, I will make a probable cause finding in absentia, and I will leave the $25 bond in place on the capias. Thank you. Next will be Genmont McKay.
He's approaching, Judge Jeremy.
Thank you.
Good morning, Your Honor.
Good morning, Mr. McKay. Mr. McKay, you're here on a misdemeanor capias. This relates to a charge for criminal mischief. I find probable cause, and I will hear from the parties.
Judge, as you could see from the case number, this is a 2008 case over
Yes.
about 12 years ago.
I do see that.
Judge, Mr. McKay is actually finished serving a state sentence. His EOS date was 2 days ago, February 4th.
Okay.
He was transported here to Broward County. So he's been in custody, for a long period of time. Obviously, he has no sort of financial resources to post his bond. First, he wanted me to see if the state had a plea offer. Maybe there's some sort of notes in there. So that's what first we're going to be asking for.
Okay.
Is he there? I'm curious. I know this McKay. It'd be adjudication time served, Judge.
Adjudication time served.
Do you wish to accept that?
Yes, ma'am.
All right. Mr. McKay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you. And now you can put your hand down. And Mr. McKay, do you understand everything we've discussed here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor.
Do you need any more time to speak with your attorney?
No, Your Honor.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
Yes, Your Honor.
Is there anything about that illness today that impacts your ability to accept this plea?
Not at all, Your Honor.
Okay. And do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Yes, Your Honor.
And Mr. McKay, what plea do you wish to enter? Guilty or no contest?
No contest, Your Honor.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you, sir.
Thank you, Your Honor.
You're welcome. Next will be Jordan Shaw.
Mr. Shaw? Jordan Shaw. Oh, Judge, I've been informed he's medical reset.
Okay,
Sorry.
that's all right. Yes.
I just,
Judge, in light of the allegations in this probable cause affidavit, I would have no objection if this case were transferred to Judge Lerner Wren.
I agree.
Okay, all right. At this time, I'll make a finding of probable cause, and I will sign a transfer order to transfer Mr. Shaw's case to Judge Lerner Wren's Mental Health Division.
I'll let her judicial assistant know.
Thank you. Next will be Sean Young.
Please approach, Judge.
Judge, I do have an argument in this
Okay.
case. And I may be just arguing in a vacuum here, but
All right, well, hold on. Don't get ahead of me. Hold on. Hold on. All right. Good morning, Mr. Young. You're before the court on 4 charges. Count 1 is for false identification given to law enforcement. 2 is for disorderly intoxication in a public place. 3 is resisting an officer obstructing without violence. And 4 is for trespassing of an unoccupied structure or conveyance. Yes, Mr. Miller.
Judge, as to counts 1 and 3, they seem to be based on the same facts that he allegedly gave a false name to the law enforcement officer. I would argue, and this would just be for classification purposes because I see there's not a bond, but I would argue that charging for both of these is excessive, and I would ask the court to find probable cause only for count 1. As for count 2, there's no allegation. They said he was disorderly. There's no allegation of any disorderly. In fact, they say when they made contact with him, he was laying down, drinking a beer. So I don't see any disorderly conduct here, and I don't see any disturbance. So I'd argue there's no probable cause for that as well.
Okay. Mr. Linder?
All right, I'll keep it brief because it's really not that
Yes.
huge a deal, frankly. But I would note, 1, you can be arrested for false ID and resisting without violence. There are elements that separate the two.
Okay.
But I would also note, one could argue that his refusal to give his name could be considered obstructing the officer. The case law is clear. If he's conducting an investigation, a trespass investigation, he is allowed to ask identifier questions to be able to determine if the person's been trespassed and if they haven't, to issue the trespass warning. So the refusal to give the name is the obstruction. The giving the false name is the false ID.
All right.
As far as the disorderly intoxication, I have no issue with the court finding no PC on that count.
Okay. I'll find probable cause with regard to counts 1, 3, and 4. I find no probable cause with regard to count 2. And I'll hear from the parties on count 1.
Judge, Mr. Young asked me to see if there's a plea offer on behalf of the state today.
I will absolutely make an offer on all counts. Mr. Young has to understand that the court has found no PC for disorderly intoxication, which he would be pleading to.
Let me explain that to him.
On that count, the offer be a withhold, by the way.
On count 2?
Yeah, it'd be adjudication time served on 1, 3, and 4. On the disorderly, it'd be a withhold.
Judge, he wishes to accept the state's offer.
Okay. All right. All right, Mr. Young, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, now you can put your hand down. And Mr. Young, do you understand everything that's been discussed here today?
Yes.
Is anyone forcing you to resolve your case?
Oh, no.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, that taking a plea today will subject you to deportation or other immigration changes?
Okay.
Was that a yes or a no?
Yes, I heard you.
Okay. And you understand that, sir?
Yes, I understand that.
All right. And Mr. Young, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it is freely and voluntarily given. So the sentence as to counts 1, 3, and 4 will be an adjudication, time served. The sentence with regard to count 2 will be a withhold of adjudication plus court costs. Good luck to you, Mr. Young.
Thank you, Your Honor.
Thank you. Next is going to be Michael Miranda.
Judge, he's present here at Maine. He declined the services as private counsel. My understanding, he's going to hire private counsel, Mr. Scott Heckler.
Okay.
Michael Miranda, he's the reset. Oh, Judge, I apologize. He's been medically reset.
Michael Miranda?
Yes,
Okay.
Miranda.
All right, thank you. Next will be Derek Miller.
Mr. Miller, come on up, please. He's approaching, Judge.
Thank you. Good morning, Mr. Miller. You're before the court this morning on one charge of battery on a person 65 years of age or older. I find probable cause, and I'll hear from the parties.
Your Honor, Mr. Miller was arrested December 13th of last year for a battery against the same alleged victim. The charge was dropped January 7th of this year. I do have a concern for the victim's safety going forward. What I would be requesting in exchange for a lesser bond than I would normally ask for under these circumstances, I would ask the court to set a $3,500 bond with pretrial and random testing.
All right, Mr. Romero?
And obviously no victim contact.
Judge, certainly, I just informed Mr. Miller as far as what the state advised us, that the case was dropped. However, Mr. Miller advised me that he can't afford any sort of monetary bond. My understanding right now, he's not working. My understanding, he knows nobody he can contact that can help post his monetary bond. So right now, he's, for all and practical purposes, financially indigent.
Bond will be set at $2,500. If Mr. Miller does post his monetary bond, he will be placed on pretrial supervision and subjected to random testing. That means no alcohol, no intoxicants. There will be a no victim contact order, Mr. Miller, so that you understand. That means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you.
Mr. Romero, do we need a photo order?
Yes, ma'am.
Judge, yes, we're going to be needing a photo order.
I'll sign it. Next will be Devin Jeffries.
He's approaching, Judge.
Okay, we have a correction on Mr. Jeffries? Okay, what's the correction?
Count 5, Judge.
Yes?
We corrected the case number,
Okay, what is it?
and the case number is the case number should reflect 18014013 CF 10A. We have attached the corrected action form.
All right, thank you very much. All right, good morning, Mr. Jeffries.
Good morning.
Mr. Jeffries, you're before the court on 5 charges. Count 1 is for attaching a registration or license plate not assigned to the vehicle. 2 is for failing to register a motor vehicle. 3, driving while license suspended, second offense. 4 is operating a vehicle with unsafe or improper equipment. That count is not for magistrate. Count 5 is a felony probation violation, which has a no bond hold. I do see you're set to go before your division judge on that matter tomorrow morning. I find probable cause, and I will hear from the parties if they wish to be heard on count 3.
Nothing to add, Judge.
All right. In light of that, the standard bond on count 3 will remain in place, and Mr. Jeffries, as I said, you'll see your division judge tomorrow morning. Victor Rodriguez.
Mr. Rodriguez is approaching, Judge. Come on
Thank
up,
you.
sir.
Good morning, Mr. Rodriguez.
Good morning, Your Honor.
Mr. Rodriguez, you're before the court on 5 charges. Count 1 is for grand theft of a firearm. 2, committing a second-degree felony with a weapon. 3, possession of methamphetamine. 4, possession of cocaine. 5 is possession or use of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Your Honor, count 2 should be a third-degree felony, so I'd ask that that bond be reduced to $2,500.
All right, let me make that note. On count 2, it should be third.
I don't have access to his record outside of Broward if one exists. I do see a 2017 DUI property damage in Broward. I'm asking that the bonds remain in place based on the allegations.
Mr. Romero?
Judge, we're just going to be requesting a medical screening order.
All right, I will sign that order, and I'll leave the standard bonds in place with the correction that count 2 is now $2,500. All right, thank you.
I have Lewis next.
Next will be Michael Stanquist.
He's approaching, Judge.
Thank you. Good morning, Mr. Stanquist. You're before the court on 8 charges. Count 1 is for possession of fentanyl. 2, possession of heroin. 3 is for possession or use of drug paraphernalia. 4 is a felony capias related to a charge for felony petty theft. 5 and 6 are misdemeanor capiases. Those are related to charges for petty theft and resisting or obstructing without violence. 7 and 8 are also felony capiases. Those relate to charges for grand theft auto and driving with a suspended license. I do see on here counts 4, 7, and 8 each have no bond holds and are not for magistrate. And Mr. Stanquist does have a hearing before his division judge on those matters tomorrow morning. I find probable cause. Do the parties wish to be heard on the other counts?
No, Judge.
All right, so those standard bonds will remain in place at this time. Thank you. Isaac Lewis.
North Broward.
Thank you.
North Broward, Your Honor, Isaac Lewis is a refusal.
All right, Mr. Miller, does your office represent him? Okay.
Judge, I can advise the court that we did represent him on count 1. We do not at this time. I guess I could request the court appoint us to represent him on this matter. And I could waive his presence. He's going to see his division judge tomorrow anyway.
Okay. All right. In light of that, I will grant the request and appoint the Public Defender's Office to represent Mr. Isaac on these charges. The charges that are before the court, which includes the VOP and the ad charges 2 through 7. I will make a probable cause finding in absentia. I do see he has the VOP hearing before his division judge tomorrow morning. So in light of that, I will leave the other standard bonds in place. I do need a recommendation from the parties on count 2, which is the burglary count.
Considering he's on probation for burglary of a dwelling, Your Honor,
Yes.
I'm requesting a $15,000 bond on count 2.
It just seems to be overkill, Judge. I'm taken aback.
Okay, well, because he is out on probation for the same exact charge, and he is seeing his division judge tomorrow morning, based on those circumstances, I will grant the request, and then I will let Judge Fine decide tomorrow what he would like to do about Mr. Lewis's cases. All right, next will be Mark Gurley, 15, yeah. 15,000 on count 2.
North Broward, Your Honor.
Thank you. Good morning, Mr. Gurley.
How you doing, ma'am?
You have a correction on Mr. Gurley's? Okay, what's the correction? Yes?
If we can correct that case number to reflect 15006535 CL10A. That's not what's on.
6535, okay. All right, I made the correction. I gotcha. Thank you. All right, Mr. Gurley, you're before the court this morning on 6 charges. Count 1 is for false reporting concerning planting a bomb, explosive, weapon of mass destruction, or use of firearms in a violent manner. Counts 2, 3, 4, 5, and 6 are for felony probation violations. Those each have a no bond hold. I do see you have a hearing before your division judge tomorrow morning on the VOP matter. For the record, I find probable cause, and I will hear from the parties with the recommendations on count 1.
Your Honor, based on the allegations, and I would note the multiple violent offenses that Mr. Gurley's on probation for.
Yes.
I'd be requesting a $50,000 bond, pretrial release GPS monitor, no contact with any employees, and no return he may not go within 500 feet of Keola's transportation service, no possession of any firearms, weapons, ammunition.
All right, Mr. Miller?
Judge, I did speak with Mr. Gurley this morning. We're not going to object to the state's request. He's going to be seeing Judge Porth tomorrow, and they can discuss it further.
Okay, all right, that sounds good to me. Then on count 1, bond will be set at $50,000. If Mr. Gurley does become eligible for release and or posts his monetary bond, he will be placed on pretrial supervision and put on a level 2 GPS monitor. There will be an order of no contact and no return. I just want to make sure I have the name of the location.
Judge, this all took place over the phone allegedly, so there was no action going to place, I think.
Well, I'm still going to impose the no return order just so that he does not go there. That's Keola's Transportation Service. It's Keolis. Mr. Gurley, that means that you're not to have any contact with any of the employees at that business, and you are not to be at that business. Do you understand that?
Yes.
All right.
Can I ask you a question?
One-
Can I ask you a question?
one
Isn't
moment.
our char-
Hold on one moment, Mr. Gurley. There's also going to be an order that you possess no weapons, firearms, or ammunition. If you are in possession of any of those items, then they need to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes.
Okay, what is your question?
Is my charge is filed?
Yes.
Has the charge been filed in this case?
No, he was just arrested on an arrest
Okay.
warrant.
No, it hasn't been filed
Actually, I
yet,
don't
sir,
have anything to
because it's a brand new case. Okay, and you're gonna be seeing Judge Porth tomorrow morning.
All right.
All right, thank you. All right, next will be Jeremiah Bray.
North Broward, Your Honor.
Thank you. Good morning, Mr. Bray.
Good morning.
Mr. Bray, you're before the court this morning on one charge for burglary with assault or battery. I find probable cause.
Your Honor,
And,
the state is not going to object to the court setting a bond
All
in
right.
this matter, and this is solely because of the alleged offense date of early 2018.
yes,
That being said, the state does have great concerns about Mr. Bray and safety in the community. One, the court should be aware, we have filed an information in this case,
Okay.
and it was filed as a punishable by life burglary with battery. I would note as the court has read the warrant, this is a very serious situation where a different individual in the vehicle with the victim was attacked with a butcher knife by someone else.
yes.
Mr. Bray and another individual basically pulled the victim, in this case, out of the vehicle. He was he was brought up here from Dade County. He was taken into custody in Dade County only based on a new law offense, a battery, that he has pled out to. And false name. He also had a previous arrest, 2017 in Palm Beach, for aggravated assault with a firearm and domestic violence battery that was dropped. He has warrants out of the state of Georgia right now for, looks like, 3 separate violation of probations. Actually, there was a failure to appear May 15th of 2018. Probation violation warrant issued March 1st of 2018. And another probation violation warrant issued January 24th of 2018. And this is from priors in Georgia that include domestic violence battery in 2017, theft 2017, and a failure to appear in 2017, giving false name to law enforcement, 2015. So in light of the prior violence, the violence alleged in this case, the failures to appear, and also that he has actively tried to avoid apprehension by giving false names in the past, the state would be requesting a $30,000 bond, pretrial release with a GPS monitor, and no victim contact.
Mr. Miller.
Judge, Mr. Bray is probably going to have trouble coming up with the $30,000 that the state is requesting. He is a lifetime resident of South Florida. He says he's lived at his current address for the past 2 years. He works as a real estate assistant. He's been doing that for the past 2 years. And he also works at a hair salon, which he's been doing for the past 4 years. He does have family in South Florida. He does support a 7-year-old nephew, currently with a roommate right now. And he advises that he's a registered voter. I don't know. I certainly can't verify that. I can advise the court that the co-defendant in this case, that's listed on the warrant, she was given a bond of $15,000 back in 2018. And also, it doesn't show that she was put on a GPS monitor.
Okay. I do note that. We don't know what her priors are as we sit here today. So,
Yes, ma'am.
I mean, obviously, Mr. Bray's prior history that's been presented to the court this morning is a bit concerning in light of the present allegations. Bond in this case will be set at $20,000. If Mr. Bray does post his monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Mr. Bray, so that you understand the no contact order, you're not to be in the same place at the same time as the alleged victim. Since you will be on a GPS monitor, that includes a 500-foot stay away order. That also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
Yes, ma'am.
All right, thank you.
Yeah, I can get that to you.
John Nunali.
Could you pull it off of the safe room?
He's in court, according to the folks at North Broward.
Okay. Then we'll reset him. Nerlens Similian.
Also in court, Judge.
Okay, we'll have him reset. Predley Alsenet.
North Broward.
Thank you. Good morning, Mr. Alsenet. Mr. Alsenet, you're before the court this morning on 4 charges. Counts 1 and 2 are each a separate charge for touch or strike battery. 3 and 4 are each a felony capias. Those are related to charges for possession of substance cathinones and trespassing. Judge Porth has issued those with a no bond hold, and they are not for magistrate. I find probable cause. I do see that Mr. Alsenet has a hearing before Judge Porth tomorrow morning. In light of that, do the parties wish to be heard on counts 1 and 2?
Requesting order of no victim contact.
Okay. Mr. Miller, anything further?
Nothing, Your Honor.
All right, there will be a no victim contact order in this case. Mr. Alsenet, whether you know the alleged victims or not in this case, so that you understand no victim contact means no being in the same place at the same time, no phone calls, no text messages, no third-party contact, no social media. Do you understand that, sir?
I'm still going. She can't do nothing to me.
I'm sorry? All right. You'll be seeing Judge Porth tomorrow morning, sir.
Yes, ma'am.
Maurice Johnson.
He's here present, Judge in Maine. After speaking with Mr. Johnson, he declined the services of public defender. He's going to hire his own private counsel.
All right.
Judge, I try to reach out to Mr. Jones, who I'm told Mr. Johnson is hiring. I left a message with the answering service, and they never got back to me.
Okay. All right. Mr. Johnson, do you understand you are entitled to have an attorney represent you for this hearing this morning?
Yes, ma'am.
And are you declining the services of the public defender at this time?
Yes, ma'am.
All right. For the record, Mr. Johnson, you're before the court on 1 count of grand theft, greater than $750, less than $5,000. I find probable cause. Mr. Linder, are you seeking anything in addition to the standard bond?
No, Judge.
Okay. In light of that, Mr. Johnson, I'm going to leave the $1,000 standard bond in place at this time. Good luck to you.
Thank you. Yes, ma'am. Thank you.
Jeremiah Howard.
He's approaching, Judge. Maine.
Thank you.
Come on up, sir.
Good morning, Mr. Howard. You're before the court this morning on a charge for attempted first-degree premeditated murder. I find probable cause.
Your Honor.
I just want to state for the record on the finding sheet, because it right now doesn't indicate attempted, I'm going to handwrite that
Of course.
in. Okay, go ahead, Mr. Linder.
Thank you, Your Honor. Relying upon the arrest warrant affidavit provided by Detective Hedges
Yes.
of BSO, I'm going to be seeking a finding of proof evident or presumption great for first appearance purposes only, that Mr. Howard be held no bond, and obviously in order of no victim contact, and this would be under a principal theory.
Judge, I also reviewed the arrest warrant. There are a lot of moving parts, a lot of bodies involved with this. I think that a finding of proof evident or presumption grade at this point is a bit of a reach. However, I understand if the court does reach that finding, and I'll allow Mr. Romero to make any arguments regarding bond.
All right, at this time, I have reviewed the probable cause affidavit that's been presented to the court. I'm going to make a preliminary finding of proof evident presumption great in order that Mr. Howard be held without bond on this charge. That is without prejudice for him to have a hearing before his division judge to further address that matter. Thank you. Travis Ward.
Please approach and judge your main.
Thank you. Good morning, Mr. Ward.
How you doing this morning?
I'm well. Mr. Ward, you're before the court this morning on 11 total charges. Count 1 is for possession of burglary tools with intent to use. 2 is burglary of an unoccupied conveyance unarmed. 3 is for grand theft greater than $750, less than $5,000. 4, illegal use of a credit card to obtain goods over $300. 5 is criminal mischief over $1,000. 6, resisting an officer, obstructing without violence. Count 7 and 8 are each a separate count for burglary of an unoccupied conveyance unarmed. Count 9 is for grand theft greater than $750, less than $5,000. Count 10, first degree petty theft. Count 11, illegal use of a credit card to obtain goods over $300. I find probable cause for these charges, and at this time I will hear from the parties.
And Judge, I'm just going to make one argument as to count 1. They don't identify a burglary tool. It seems to be a tempest in a teapot because there's so much else going on here.
I understand why you're making the argument, Mr. Miller. I just think based on the totality of the information and the circumstances contained within the probable cause affidavit, we've reached the threshold that's required for me to make a probable cause finding for today's purposes. What that means as to filing the charges later on remains to be seen. Yes, Mr. Linder.
Your Honor, I'm going to be requesting $10,000 bond on count 2. $10,000 bond on counts 7 and 8, $1,000 bond on 9, $1,000 bond on 10, $1,000 bond on 11. Your Honor, should he be eligible for release on these charges, pretrial release of the GPS monitor? The reason I word it that way is that Mr. Ward has a pending case. He has a pending burglary of a conveyance, resisting without violence, and theft. He's out on a $6,000 bond, and he was released August 30th of 2019. It would appear upon my review that every single one of these charges allegedly occurred after he was released from jail on that pending case, and every single one of these charges would be a violation of his bond and release conditions. In addition, his history includes 2017, 2 counts of burglary of a conveyance, felony.
Judge, if I may, considering what Mr. Linder said, the totality at this time, it's reasonable, his release condition, so nothing to add from the defense.
All right. Mr. Linder, do you want to continue, or may I go ahead and make a ruling?
You can go ahead, Your Honor. I was, just so the court's aware, I was bringing up his other history for the court to make an informed decision if you chose to revoke or not.
I understand. I'm not going to make a decision to revoke at this time. However, I will grant the state's request as to the bond amounts requested on count 2. Bond will be set at $10,000. On counts 7 and 8, bond will be set at $10,000. Count 9 will be set at $1,000. Counts 10 and 11 will also be set at $1,000. And as requested, if Mr. Ward does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Mr. Ward, I don't know if you know the alleged victims or not, but so that you understand whether you know them or not, no victim contact means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, no social media. Do you understand that?
Yes, ma'am.
Thank you. Next will be Anthony Pitticelli.
Yes, sir, ma'am.
Judge, Mr. Linder and I had an opportunity to discuss Mr. Pitticelli's case earlier today.
Yeah.
I said, okay, I understood you were asking for pretrial.
Judge, I'm asking the court, these charges stem from an incidents that occurred back in September. Mr. Pitticelli was arrested on January 3rd on several similar charges, and was released on pretrial January 8th. Had these been before the court at the time, I'm sure he would have been released on pretrial at the same time. On these charges, we're asking the court simply to put him back on pretrial. He does have an ELMO, as far as I understand.
Okay, well, let me just see here. Just for the record today, Mr. Pitticelli, you're before the court on 4 separate charges for burglary of an unoccupied conveyance, unarmed. I do find probable cause. And what are the pretrial conditions that he's out on right now? Or that he's supposed to be out on? Yes,
Your Honor,
Mr.
while that's
Linder.
being looked up, he's put on a combination of bond and pretrial with the GPS. One, I don't know what was argued before his judge decided to do that.
Right.
And certainly, his judge wouldn't have been aware of 4 more burglary charges. But, Your Honor, so the court's aware, it's a little bit more than several charges.
Mhm.
He's actually,
I'm sorry?
it's
33 count?
18 burglary conveyances, 1 burglary dwelling, 3 grand thefts, and 11 petty thefts. Your Honor, I'm asking, and I believe it's appropriate that some bond, considering his judge did put him on a combination of bond and pretrial with the GPS, that a combination of bond and GPS be placed on these counts.
All right. What's your recommendation?
My recommendation would be, seeing that his judge, I don't know, because it got updated, I believe, but. Well, no, because when we got ad charges and it got updated, then, it's a combination. Some are put at 2,000, some are put at 1,000. So to split the difference, I'd be requesting 1,500 on each count here.
He posted a total of $7,000 bonds on January 8th. Judge, we're just asking that he didn't pick up any new charges. I know it's been just barely a month, but I would just ask the court to put him out on pretrial again.
And Judge, and speaking of Mr. Pitticelli, my understanding is, I believe he was placed on level 1. So I don't know if that's correct or not, but that's the most restricted. So he's been adhering to his pretrial release conditions. The person who posted his last monetary bond is his father, who he resides with, and he's on disability. So he had to gather up all his funds that he could to possibly post his bond. So he's been adhering to the conditions, so he hasn't been working. So he has no sort of funds. So we're asking for level 1.
And the flip side to that is if his judge had known, oh, there's also 4 additional burglaries, pretrial might have gotten denied to begin with.
What are his other conditions for pretrial? He's on level 1 GPS. Is there anything else? Mm-hmm. All right, I understand the arguments that have been made by the defense today. I do see that these are allegations from September, but from everything I'm seeing, if these had been discovered sooner, then they would have been placed on a bond with the same conditions as the other similar or same charges. So in this case, I'm going to set $1,000 bond on each of these counts. So that's 4 counts. And if he does post that monetary bond, then it'll be the same pretrial level 1 GPS as the other counts. All right, thank you. Good luck, Mr. Pitticelli. Dustin Vogel.
He's approaching, Judge.
Good morning, Mr. Vogel. You're before the court on 2 charges. Count 1 is for possession of cocaine. Count 2 is an out-of-county felony hold that's out of Miami-Dade County. It has a no bond hold and is not for magistrate. I find probable cause. I'll hear from the parties.
Nothing from the state.
Judge, considering it as an out-of-county hold, nothing to add.
All right, in light of that, the standard bond will remain in place on count 1. Thank you. Darrell King.
Hey, Mr. King is here present.
Thank you. Good morning, Mr. King. You're before the court this morning on 10 charges. Counts 1, 2, 3, and 4 are each a separate count for possessing, receiving, or retaining a stolen credit or debit card. Count 5 is grand theft auto. 6, unlawful possession of personal identification of another. 7, resisting an officer obstructing without violence. 8 is for operating without a valid driver's license. 9 and 10 are each felony probation violations, which have no bond holds. I find probable cause for these charges. In light of the no bond holds, do the parties wish to be heard on counts 1 through 8?
No, Judge.
Not at this time, Judge.
All right, then those standard bonds will remain in place at this time. Thank you, gentlemen. Michael Mack.
Judge, we have an argument as to count 1.
All right,
North Broward.
thank you. Do we have Michael Mack at North Broward?
We have a Sammy Mack.
That's next, but I have a Michael Mack before Sammy Mack.
Judge, the docket indicates he's at main intake, so.
Right, he was transported to North Broward.
He was transported to North Broward. So I have, Deputy, it's Michael Leonard Mack.
Okay, I will find out.
Okay, I'll go ahead and go to Sammy Mack while you're working on that one for me.
Okay, thank you.
Thank you. I'm sorry?
Good morning. Good morning. Good morning.
Good morning, Mr. Mack.
How you doing?
I'm well. Mr. Mack, you are before the court on 2 charges. Count 1 is second-degree petty theft, third or subsequent offense. Count 2 is for trespassing of an occupied structure or conveyance. I find probable cause, and I will hear from the parties.
Your Honor, one moment, I'm trying to find the paperwork.
Okay.
This is the person she gave the, remember she came and handed you paperwork on the mail? It was this case. One moment.
Okay.
History includes 2014 strong-arm robbery. He was sentenced to 41 months state prison as a habitual offender. 2013 strong-arm robbery, 41 months state prison as a habitual offender. 2012 grand theft and uttering a forged instrument, 41 months in state prison. 09 grand theft, 01 escape.
Are you requesting anything in addition to the standard bond?
No, Judge.
All right. Mr. Miller?
Judge, we're asking the court to consider pretrial release for Mr. Mack. He is a lifetime resident of South Florida. He has been residing at his current address for the past 20 years. He does have family, strong family ties. He is currently on disability, and although he will try to get someone to post his bond, he's reporting he has to report for dialysis tomorrow, and he has not yet had access to a phone. A phone call, not a cell phone.
Okay. Based on the history that's been presented, I'm going to leave the standard bond in place at this time. All right. I'm also going to impose a no return order. I think he's already been trespassed from the location, but, Mr. Mack, so that you understand, the no return order means that you are not to return to the Nordstrom that is at the Sawgrass Mills Mall. Do you understand that?
Yes, ma'am.
All right, thank you very much. Okay. Sheila, what were you telling me about Michael Mack, that he's at Maine? Okay, let me go see. Deputy, was there something you wanted to tell me?
That was it, ma'am. Michael Mack is at the main jail.
Okay, let me go over to Maine. Mr. Romero, do you have Michael Mack over there?
They're checking, the deputies are checking right now their system.
Okay, I'm gonna keep going and we'll come back to him. Next will be Melvin Henderson.
He's approaching, Judge. Come on
Thank
up,
you.
Mr. Henderson.
Good morning, Mr. Henderson. You're before the court this morning on 6 charges. Count 1 is for second-degree petty theft, third or subsequent offense. 2 is for resisting an officer or obstructing without violence. 3 is for second-degree petty theft, third or subsequent offense. 4 is a misdemeanor capias. That relates to a charge for felony petty theft. 5 is second-degree petty theft, third or subsequent offense, and 6 is an out-of-county felony hold that is out of Palm Beach County and also relates to a felony petty theft charge. That charge has a no bond hold and is not for magistrate. I find probable cause. Do the parties wish to be heard on the remaining counts?
No, Judge.
Judge, at this time, Mr. Henderson said he can't afford anything, so he wanted me to let you know that.
Okay, I understand. In light of the no bond hold that's in place on his out-of-county hold, I'm going to leave the standard bonds in place this time. Thank you. Next is going to be Mr. Mujahid's case.
Judge, have an argument as to 1, 2, and 3.
Majad is bonded.
He's
Never
bonded.
mind.
All right, it was a good effort, Mr. Miller.
And Judge, I've been informed by the deputies, yes, Mr. Mack, I believe, is still in processing.
Okay.
He's still here. Can we reset him for this afternoon?
Yes, that's fine. So we'll hold him for the PM. All right, next is going to be Alexander Melnikov. Will you hold this for the PM docket?
Conti, Your Honor.
Thank you. All right, good morning, Mr. Melnikov.
Good morning, Your Honor.
You're before the court this morning on a change of charge. The original charge was tampering in a misdemeanor proceeding. This has been changed to tampering in a third-degree felony proceeding. I find probable cause. Mr. Linder, what do you want to tell me?
Judge Allspector originally set the bond at $500 plus pretrial plus no contact. It's still her case. I'd ask that the same bonding conditions be
No objection.
placed back.
All right, is that standard pretrial?
Yes.
Okay, then I'm gonna leave the same conditions, so that's gonna be a $500 bond, and once again, if Mr. Melnikov posts that bond, he'll be placed on standard pretrial supervision, and Mr. Melnikov, the no victim contact order remains in place. Do you understand that?
Your Honor, I understand that. What is a standard pretrial supervision?
Standard pretrial supervision is the lowest form of pretrial supervision. They'll put their own requirements on you that often requires you to call in to pretrial supervision once or twice a week, whatever it is they're requiring of you. But if you post your monetary bond, you'll meet with pretrial and they will explain all of that to you.
Okay, thank you, Your Honor.
You're welcome. Good luck. Next will be James Bryant.
Reset, Judge?
Are we resetting him to PM or resetting him to tomorrow? Or is he a medical reset?
Tomorrow.
Okay. And Donald Fruster.
He's here. Mr. Foster, come on up, please.
All right.
Come on up.
I have been told, confinement has just advised me Mr. Fruster's bond has been posted. So for the record, I find probable cause. All right, thank you. Okay, amazingly, that brings us to the end of our morning docket. How about we start at 1:30? Is that gonna work for the jails?
That's fine.
All right. So we'll start back at 1:30 this afternoon. Thank you,
We have,
everyone.
Thank you, Your Honor.
We have a